Rape and sexual assault are often used interchangeably. Oftentimes, they're used to describe the same act in some instances. But there are important differences in how both these terms are historically and legally defined. The word rape dates back to 14th century France, where it meant to seize property. We've talked about how women and rape were used to designate property to women. Let me scratch that. Used to designate women as property. Sexual violation rarely entered into historical connotations of rape, which focus more on issues of force and power. Today, rape refers to any sexual penetration, whether it be vaginal, anal, or oral, of a person without his or her consent. Prior to recent changes in the legal definition, rape was much more limited in scope. Sexual assault is a much broader term that encompasses a variety of behaviors that can be considered sex crimes, including voyeurism, exhibitionism, and even sexual harassment in some cases. To put it concisely, all rapes are considered sexual assault, but not all sexual assaults are considered rape. The differences between defining rape versus defining sexual assault can be tricky in some circumstances, particularly when charging and prosecuting offenders, an idea to which we have all returned to later at the end of the presentation. Apart from definitional differences, the term rape and sexual assault are used interchangeably in this chapter. Currently, rape is one of the 8 Part 1 index crimes for the Uniform Crime Reports published by the FBI. So it's considered one of the most serious crimes. While rape has been a crime with severe punishments for offenders, it has not been classified as a violent crime throughout history. This section presents a survey of the history of rape, which we've talked about briefly before in other lessons, and how social reactions have led to changes in how we view rape into the much more broad and common sexual assault today. So historically, women were viewed as property, and a sexual assault was a violation of property. Men were responsible for how women were cared for: fathers, husbands, sons, if the husbands happened to die. So, rape, therefore, whether against a man's daughter or a man's wife, was treated as a man on man crime. It was a property crime committed by one man against another man's property. Now, no property was more valued than a betrothed woman or daughter. So, raping a woman who was betrothed, who was assumed to be a virgin, was treated as a capital offense, with offenders facing the death penalty and the victimized girl considered guiltless. On the other hand, married women who were raped did not receive the same sort of treatment. A married woman who experienced the same crime had to share the blame equally with her attacker. The crime was labeled adultery, and both parties were thrown into a river. And this is talking when we're in ancient Samaria here, the time of Hammurabi. And we know about this because of the Hammurabi Code. The remnants of these policies are evident in some rape myths that we even see today, where sexually promiscuous women are considered equally blame or partially to blame for their victimization, whereas uh, virgins or non-sexually active women are considered guiltless or not blameworthy. So Beginning in the 1970s in the US, little had changed with respect to how rape was handled by criminal justice officials. Rules of evidence required a victim to physically resist her attacker, and the victim's testimony often required corroboration. Evidence of the victim's prior sexual history was admissible during trial proceedings. Traditional rape law made it, quote unquote, easy to commit rape and get away with it. Critics argued that these rules and laws had serious consequences for both the victim and the CJ system. They were partially responsible for the unwillingness of victims to report rape, which accounted for low rates of arrest, prosecution, and conviction. Critics also charged that the CJ response to rape was predicated or based on rape myths present in all the actors in the CJ system. So, all the way from the line level police officer to the supervising police officer to the chief to the district attorney and the ADA who would prosecute the crimes, all the way through the jury members and the judges. Recall the difference between the quote unquote real rape and what actually legally is a rape. So, the approach clearly reflected several situational and attitudinal rape myths, particularly that rape only happens to unmarried young women or girls. Now, during the 1960s and 70s, the feminist movement was present in the US, along with other social reforms at the time. So, the women's movement was a major force for change. Right, we talked about Brown Miller, and when she published Against Our Will, this was published during the mid 1970s, which would be towards the end of the Women's Movement, Social Movement Act. And so, there again, just to summarize, she considered rape a political act and a rape of domination cons- committed in a patriarchal society where women were devalued and men were privileged or valued. So, after reading that book, many people began to listen to the message that Brown Miller was putting forth in the book, and the message began to take hold. And so by the 1990s, all 50 states had either revised or repealed traditional rape laws and the standards that were used in court to prosecute a rape or sexual assault case. So, um, although the reforms were varied from state to state, there were four common themes. Number one, the single crime of rape was replaced with a series of offenses graded by seriousness. So the traditional definition of rape excluded male victims. Acts other than vaginal intercourse, sexual assaults committed with objects were not considered a rape, and rapes committed by a spouse were not considered rapes at all. So this language, uh, or the language in the traditional statutes, was rewritten to be more gender neutral and to encompass a broader variety of actions. Recall that anal sex was often, or oral sex was often considered a different crime called sodomy, where the victim and the perpetrator could equally be held accountable. And so all of this was rewritten into the language of the law. Point two, the consent standard was changed by either eliminating or modifying the requirement that a victim resist her attacker. Again, think about this rape myth uh, that was actually present in the law. If people didn't put up a fight, how would you prove that it was a rape? So, traditional rape laws required that a victim resist, so to demonstrate her lack of consent. And I say her in a very factual sense because, again, most state statutes stated that men couldn't be victims. And so when the laws were rewritten, reformers changed the standards. And so arguing that you can't use resistance as a indicator that a rape occurred. Rather, you had to show that consent applied. and that the absence of consent is what was important when determining whether a rape or probably now in a lot of states a sexual assault occurred. Three, corroboration, which means verifying with other pieces of evidence that other fact or statement or piece of evidence. Usually, this refers to the victim's testimony. Previously, victim testimony had to be corroborated, so you had to have supporting evidence that what the victim was saying was true. So the corroboration requirement was eliminated, giving the private nature of most sexual assaults and rapes more credence and equal weight. So critics cited the immense difficulty in obtaining evidence to corroborate victim testimony as a barrier to prosecuting rapes and sexual assaults. And so that was uh, in the reform movement that was removed from those statutes. The fourth major kind of category in the reform of rape laws to probably sexual assault laws was what we referred to as rape shield laws. So these place restrictions on introducing evidence of a victim's sexual history during trial proceedings. And this goes back to the rape myth that how a woman's sexual history was used to determine whether she was a victim or not. So it didn't matter how sexually active a woman was or with whom she was sexually active. All that mattered was the facts of this instance. And so that's what rape shield laws tried or attempt to get through. So simply by focusing on the incident at hand and not bringing in a victim's prior behavior, the goal was to just look at the facts of this case. Oftentimes we see the exact same thing for accused offenders, that even if they've committed the same sort of crime, we constitutionally we give them the benefit of the doubt and don't necessarily bring those in at every opportunity that a prosecutor can. Oftentimes that's protected and shielded, as it were, from a jury. And so usually a motion or a request before a judge has to be granted to bring that evidence into the prosecution and trial of an offender. So essentially the same thing was applied to a victim. So with all of these reforms, there was the expectation that there would be arrest, convictions, and imprisonment for all types of sexual assault, including date rapes, which were hard to prosecute, right? Because they're most often acquainted by acquaintances and people that there might be a signaled intent to have a sexual relationship with, and spousal rape, which oftentimes could not even be prosecuted or was not recognized as a crime. So even though these reforms were put in place to varying degrees across different states and jurisdictions, there are several uh, critical points to review. So, despite the requirement that we no longer have to consider the resistance of the victim, as well as corroboration of testimony, officials and representatives of the CJ system in every jurisdiction still held the elements as critical indicators as whether a rape case would result in a conviction. So, again, lower line officers, uh, assistant district attorneys and prosecutors who were screening cases still look at these considerations in determining whether to accept charges and whether this will, quote unquote, play well in front of a jury in determining whether they will charge uh, an accused offender. Despite the fact rape shield laws effectively barred entering a victim's sexual history into the trial record, officials in jurisdiction uh, have fought for and received exceptions to this. So if there was a sexual relationship between the victim and the defendant, this type of evidence would likely be introduced without challenge. And additionally, um, reforms did not increase the likelihood of a conviction in any of the jurisdictions. And so, despite the fact that these reforms were placed, we didn't necessarily see this massive uptick in sexual assault cases that came from date rape, acquaintance rape, spousal rapes, and the increased reporting rate and likelihood of indictment uh, didn't also increase like what would be predicted after a reform movement like this. Also, there was considerable variability in how these reforms were implemented across the different states and jurisdictions. And so there is no requirement for the prosecution to show that a defendant used force or threat of force. However, some states require forcible compulsion or incapacity to consent to prosecute a rape case. Uh, the rape law reform movement changed the resistance requirement such that the burden was no longer on the victim to resist to the utmost. However, in 8 states, there's still a requirement that the victim still has to resist his or her attacker. And so in these states, the victim's behavior is more determinative than the defendant's actions. Again, these kind of cultural rape myths still directing how society views sexual assault and rape in those jurisdictions. Specifically, victims are not necessarily required to establish a lack of consent in some states. In many, they are, and in most, they are, but not in all. And one other thing is that the grassroots movement that became the women's movement from the mid to late 60s on into the 70s, and then led to the passage of these reforms into the 1990s, led to the Violence Against Women Act, which is a federal law we've discussed uh, in the course materials previously. And so this was a major implementation of for investigation and prosecution of violent crimes against women, including sexual assault, but also domestic violence, dating violence, stalking. Stalking was criminalized in the early to mid 90s as well. So during this uh, legal reform movement of violence against women, so restitution requirements uh, is also a part or has been a part of the Violence Against Women Act, and also increases and provides clear pathways for civil remedies for the criminally unprosecuted cases. So victims can sue their victims can sue their perpetrators far more easily. And so again, uh, Violence Against Women Act has been reauthorized uh, several times since 1994, but awaits reauthorization currently at the time of this recording in the year 2020.